Good morning, Kishore. Sir, you are in the office. Okay. So one matter,
Sir, mute ಮಾಡಿ.
23, it was decided in Lok Adalat for 2 lakh.
ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಮ್ಯೂಟ್ ಮಾಡಿ, ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ.
ಏನಿಲ್ಲ ಸರ್,
ಏನ್ ಹೇಳಿ?
ಪಾರ್ಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈಗ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕ್ಬಿಡೋದು ಸರ್.
ಪಾರ್ಟ್ ಆದ್ಮೇಲೆ ಅದೇ ಫರ್ದರ್
ನಾವು ಈ ತರ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ನೆನ್ನೆದಲ್ವಾ ಇದು?
ಹೌದು ಸರ್.
ಪಾರ್ಟ್
ಈ ತರ ಆರ್ಡರ್ಸ್ ಅಂತ ಹಾಕಿ ಕೆಳಗಡೆ ಪಾರ್ಟ್ ಹಾಕಿದ್ದೇವೆ. ಈ ತರ ಹಾಕೋಣ, ಇಲ್ಲ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕ್ಬಿಡೋದು ಸರ್.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಸೇರಿಸ್ಬಿಡಿ ಅಲ್ಲೇ.
ಹೌದಾ ಸರ್?
ಇಲ್ಲೇ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಸೇರಿಸಿ.
ಆಯ್ತು.
ನಾಳೆಗೆ ಇದೆ.
ಹೌದು ಸರ್.
Fresh matter. Fresh matter. Fresh.
Notice was ordered, but on the delay. Now, my lord, EP has been filed.
You see mine. What is it?
Time of your exam and the goods was ordered. The delay, my lord, now, my lord, EP has been filed.
Now for withdrawal of the award.
Fresh matter, man.
Adjournments page wise. From admission.
Sir,
Video ಇಲ್ಲ.
Page 8.
ಸರ್ ಕೋರ್ಟ್ ಹಾಲ್ ಕಾಣ್ತಾ ಇಲ್ಲ ಸರ್.
Court hall video.
ಬರ್ತಾ ಇದೆ ನೋಡಿ. Page 8. Serial number 32 to 35. Page 9, 36 to 40.
Yes, 38. Yes. On the court counsel.
Is hospital.
In hospital.
Is in hospital.
Hospital.
Your good name?
Baira Reddy GS.
Sri Baira Reddy submits that Sri Prakash HC land counsel on record for the appellant is hospitalized. Full stop. 6 time. Hence stand over to. Twenty-fourth, 25th October.
Please.
25th October. Page 9. Page 10, 41 to 45.
That's serial number 44, my lords. The appellant in connected matter, my lords. I pray for weeks time, my lords.
This is 2022 matter, Amma. Why are you seeking time?
But some inconvenience, my lords, due to.
Let us see when the matter is called. Next.
Kindly, my lords.
Let us see.
Page 11, 46 to 50.
49. Advocate for the appellant, undercut counsel has expired. To vacation listed because I have to secure the files from the office, home office from the scene. So
Your good name, Mr. Counsel.
Supreet BP.
Sri Supreet submits that Sri Shivakumar P. land counsel on record for the appellant is no more. And that he would be filing wakalat and would be conducting the case representing the appellant. Full stop. 6 time.
My lord, serial number 49, my lord.
49, sir.
In
Please,
the
my lord, please.
submission
Please, my lord.
was made, comma, stand over to 24th October.
My lord, serial number 46 and
24th October is after
October,
vacation.
after vacation.
Yes.
ಇಲ್ಲ ತಗೋಬೇಡಿ.
serial number 46 and 47 may be referred to Adalat.
Mention ಮಾಡಿ.
46 and 47.
Please
Look
refer
at
to
that.
Adalat.
46.
I will inform the already other side.
46 amma, at request of land counsel for respondents 1 and 2, the matter is referred to Lok Adalat for settlement.
47 also.
47 at request of land counsel for the appellant, the matter is referred to Lok Adalat for settlement.
Much obliged.
My lord, one submission, serial number 56, my lord,
1 minute.
MFA 8198.
Page,
Minute. Yes.
page 12, 51 to 55. Page 13, 56 to 60.
In this, my lord, serial number 56, my lord,
Yes.
MFA 8198 of 23. Your lordship, yesterday I filed the wakalat. Kindly direct the office to show the name of Sri H.C. Betsur for R2.
R2 का
R2.
HS लिंगराज जो इधर है.
Yesterday I filed the wakalat in this.
Our wakalat ಹಾಕ್ಯಾರ ಅವ್ರು.
Yes, Mr. Lingiraj.
No, I was directed to take notice. The copy I have sent. The company has entrusted the matter to Betsur. Betsur name may be sure.
Wakalat is filed by Sri H.S. Lingiraj.
HC Betsur.
Wakalat not filed. H.C.
Wakalat
Lingiraj.
yesterday I filed.
Sri H.C. Betsur submits that he filed wakalat for respondent number 2. Full stop. Sri H.S. Lingiraj appears through VC and submits that the matter was entrusted by respondent number 2 to H.C. Betsur. Full stop. In the light of the submission thus made, office is directed to put up the wakalat filed by Sri H.C. Betsur and to show the name of Sri H.C. Betsur in the cause list hereafter.
Much obliged.
Page 13.
List on
Sir, serial number 16.
8th November.
Page 13. आयका. Page 14. 61. Page 15, 62 to 66.
60? 63, yes.
Awaiting TC.
Await records not yet received from the consent tribunal. Therefore, stand over to 24th October.
Okay. Serial number 66, my lord. We have informed the appellant also. Appellants also raised time in this matter, my lord. Small
Why?
inconvenience. So far as the major portion, the appeal is, the claim petition is dismissed, my lord. The major, all the documents are in Kannada, my lord. That's why it's secured this one.
I'm appearing for the appellant
appellant.
some other day, lordship.
I represent PB Raju, my lord.
You are representing
PB Raju. I am PS Jagdish.
Sri P.S. Jagdish, representing PB Raju, Land Council on record for respondent number 2 seeks time. Hence, stand over to 24th October.
Please.
Page 16, 67 to 70.
69, my lord.
Yes.
Senior held up in some family emergency situation, my lord, so he could not.
Your good name?
Lohit, my lord.
Huh?
Lohit.
Sri Lohit, representing Sri Jagadish Baliga, Land Council on record for respondents 1 and 2 seeks time. Hence, stand over to 8th November.
Submission, my lords, memo, my lords, fresh matter, my lords, it's been a 7 weeks, my lords, it's not listed, my lords, kindly.
Yes.
For orders, serial number 1, Manjula Tejasvi. Jagadish 50.
I for the respondent.
Your Lordship, I am appearing for the appellant herein. I had taken steps in the month of August, Your Lordship.
Second.
Recently, in August 2024. If they have not been served for some reason, I'll do the needful once again, Your Lordship. For the second time, it is coming, Your Lordship.
Srimati Manjula N. Tejasvi appears through VC and seeks time to furnish the requisites. Time for a week is granted. on furnishing the requisites, office to send notice to respondents 4 and 5. List on 7th November.
Highly applies, Your Lordship.
Serial number 2, P. Shivakumar, S. Nirmala.
I am for the appellant in 1745, my lord, of 21. And I have not been served the copy, my lord, hence I could not file the wakalat. Only it is directed to take notice. The copy was not served, so I could not send it to the company, my lord.
I'll serve the copy minutes by next.
These matters are of the year 2021, Amma. Huh?
My lord, it is not my mistake, my lord. My appeal has been filed long back. Only he could not serve it when it was directed on 14/8 to serve the copy and take the notice, my lord. When he could not serve the copy, I cannot take the wakalat from the company without the appeal copy, my lord.
Have you filed your wakalat?
No, my lord. I could not file it because
Not you. Have you filed your wakalat?
Along with P. Shivakumar, I have signed in the local.
In the connected matter, you have not filed wakalat.
No, my lords. As a respondent, I have not.
in my appeal, he has not filed it.
Take the wakalat in 2182 of 2021.
In my appeal, he has not filed it, my lord.
First matter, wakalat for the appellant. Yes. Sri Supreet BP submits that along with Shivakumar P, he accepted the wakalat in MFA 2182 of 2024. Full stop. As Sri Shivakumar P is no more, comma, office is directed to show the name of Sri Supreet BP in the cast list for the appellant in MFA 2182 of 2021. Next. Learned Counsel Sri Supreet BP seeks time to file wakalat for respondent in the connected appeal, that is in MFA 1745 of 2021. Full stop. Time for 2 weeks is granted. Next paragraph.
And he may be directed to serve the copy.
Nirmala appears through VC and submits that she is appearing for the claim, she is appearing for the appellant in MFA 1745 of 2021. Full stop. However, she was not served with the appeal papers in MFA 2182 of 2021 and therefore she could not file wakalat for the respondent therein. Full stop. Appellant to serve copies of appeal papers immediately. Full stop. Time for 2 weeks is granted to Srimati S. Nirmala to file wakalat for the respondent in MFA 2182 of 2021.
Achha.
List both the matters on 25th October.
Much obliged.
Let it.
Serial number 3, Nagaraja M.
Appellant in this case, Your Honor.
P. Pradeep for
I am for
R1.
respond number 1, Madam.
Week's time may be pleased, Your Honor. Today I am going to file the IA
What application for correction?
for rectification of MEC number
In appeal memo,
found in
Madam.
the
Mr. Counsel, these are 2021 matters. Huh? Why you have not filed application by now?
today I am going to file the IA.
Learned Counsel Sri Nagaraja M seeks time to file necessary application for correction in the memorandum of appeal in both the matters, huh?
Only one MFA number 2357 of 21.
MFA 2357 of 2021.
Another MFA, it is rightly
Full
mentioned.
stop. Time for a week is granted. List both the matters on 30th September.
Much obliged.
Serial number 4. Petitioner Sriram General Insurance Company.
I appear for respond number 2, my lord.
Who is appearing for the appellant?
My lord, in this case, my lord, insurance company filed the appeal, my lord. HN Keshav Prashant. Keshav Prashant is no more, my lord.
No representation on appellant side on call. Full stop. Sri KV Naik, Land Counsel for Respondent number 2, submits that Sri HN Keshav Prashant who filed the appeal is no more. Full stop. In the light of the submission thus made, comma office is directed to issue notice to the appellant to engage a counsel and to pursue the matter. List on 7/11.
Please, that's all.
Serial number 5. Mustaq Ahmad.
We have paid my lord today morning.
Sri Mustaq Ahmad for appellant submits that needful is done. Full stop. Office to verify and to send notice to respondents. List on 6/11.
Serial number 6. Jagadish HT.
For the appellant in this
D
case.
Pradeep for R2.
Now for dispensation of notice to Arman Marada. Respond number 2 is the admitted the liability, Marada.
Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Sri Jagadish HT, Land Counsel for appellant, submits that as respondent number 2 admitted its liability, comma notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma notice to respondent number 1 stands dispensed with, however at the risk of the appellant.
Delay of
Next.
150.
Orders in IA 1 of 2022. Any objection?
No objection. Delay days may be condoned not entitled interest, my lord. 157 days delay.
157 days.
Seeking the court to condone the delay of 157 days in filing the appeal, comma this application is filed. Full stop. Heard Sri Jagadish HT, Land Counsel for the petitioner appellant, as well as Sri Mallikarjun Reddy, who represents Sri B. Pradeep, Land Counsel on record for respondent number 2. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the grounds urged, comma the delay as prayed for is condoned. Full stop. However, the petitioner appellant will not be entitled for any interest over and above the amount that is given by this court through the judgment in the appeal for the period of delay of 157 days. Next, admit, call for the records from the consent tribunal, list the matter under the caption final hearing on 5th November.
Please.
Please, my lord.
Serial number 7. Shweta Anand.
With your lordship's kind leave. My lord, I have given no objections a long ago. So I have informed the KSRTC also today. My lord, amount also has been deposited, it seems. They will file the necessary documents by this week, they say. A week's time may kindly be granted for compliance of the same. They will file a memo, they say.
They should have filed by November.
I know, my lord. I'm sorry, my lord, because I was not in, because I had already given. I submitted on the last occasion also. Maybe there is some miscommunication. I will inform the KSRTC. I have informed them already. And it has been paid. 50% deposit amount has been already done. That also I will file.
Shweta Anand appears through VC and submits that she has given up wakalat. Wakalat, full stop. She also stated that she informed the same to the appellants. Full stop. However, the appellants have not engaged any other counsel. Full stop. Proof of depositing 50% of the award amount as ordered by this court is not filed yet. Full stop. Therefore, as per order dated 3/9/2024, the appellants proof of deposit of 50% of the award amount is not filed yet.
We will file it, my lord. It has been paid already. It has been deposited.
No, ma, we
That
have not-
undertaking your lordship may kindly record from me.
Why
Because
should we record the undertaking if there is no proof of filing?
otherwise
how
I'll
can
do
we
one
file?
thing,
At least
my
after
lord.
our order, the appellant should have taken care.
True, my lord. There is some
Now it is not
miscommunication.
filed. This shows
No, no,
negligence and at least if you have not obliged the orders of the court, we are at obligation to
No,
oblige
no, my lord, it has been complete. I'll do one thing, my lord. May request, my lord, before in the evening we will file it, my lord. We will file the same before evening today. I'll see that it is filed.
What did you write, Amma? Is not filed. Is not filed yet. You remove that yet. The appellants are at liability to deposit the entire award amount as per order dated 3/9/2024.
2-3 ಸಲ ಫೋನ್ ಮಾಡಿದೆ.
However, such deposit is also not filed. Full stop. Land Counsel Srimati Sweta Anand submits that proof of deposit would be filed during the course of the day. Full stop. To give fair opportunity, the appellants are permitted to file proof of deposit during the course of the day. Full stop. In case proof of deposit is not filed, stay granted through orders in IA 1 of 2022 shall stand vacated by 5 p.m. of this day. List on 5th November.
Much obliged. I'm sorry, my lord. Maybe some mistake. Much obliged.
Serial number 8, Sanat Kumar KM.
Dispensation for R1, my lord. R2 is the future general, my lord.
In connected
Yes.
matter, I have appeared, my lord, so I'll take notice in this matter also.
For R2,
R2.
My lord.
yes.
In connected matter, that has been disposed of already.
Sri
PS Jagdish.
P.S. Jagadish waives notice for respondent number 2. Full stop. Seeks time to file wakalat. Time for 2 weeks is granted to file wakalat. Appellant to serve copies of appeal papers at the chambers of Sri P.S. Jagadish. Full stop. Next paragraph. Memo seeking dispensation of notice upon respondent number 1 is on record. Full stop. Land Counsel Sri Sanat Kumar KM submits that as respondent number 2 admitted its liability.
Respondent 3.
Respondent number 3 admitted its liability, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. List on 22nd October.
Much.
Serial number 9, Chetan B, B.A. Ramakrishna.
My lordship. Memo for dispensation of notice to R1, my lordship.
Memo seeking dispensation of notice upon respondent number 1 is on record. Why it should be dispensed with?
Liability fixed against my lordship, insurance company, my lord. There is no dispute regarding.
Sri Chetan B, Land Counsel for Appellant submits that as liability is fixed upon respondent number 2, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellants. Next paragraph.
Ready, my lordship.
No representative. Who is for respondent number 2?
B.A. Ramakrishna.
Heard Sri Chetan B. No representation on respondent side on call. Admit, list the matter under the caption final hearing on 26th September. Not 26th, 27th September.
Please.
Serial number 10, Pradeep Kesi.
Appellant, my
Again,
lords,
business owner.
we have filed memo for dispensation of notice to respondent number 1, my lords. As insurance company, I have admitted the liability, my lords.
Memo seeking dispensation of notice upon respondent number 1 is on record. Next. Heard, Miss
Pavana.
Land Counsel who represents Sri Pradeep HC, Land Counsel on record for the appellant. Full stop. Land Counsel states that as respondent number 2 admitted its liability, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next. Heard, Miss Pavana. No representation on respondent side on call. Admit, list the matter under the caption final hearing on 30th September.
Please.
Serial number 11, Vijay Kumar T.M.
For the appellant, my lordship, cost of case 5,000 all paid.
Where is the proof?
Appellant, advocates library.
You have not filed proof of having paid.
Today, we should the office.
Take it. Yes. Office objections are complied?
Yes, my lordship.
Your good name?
Pundalik Chauhan. P-U-N-D-A-L-I-K, Pundalik
Pundalik
Chauhan.
Chauhan. Sri Pundalik Chauhan, representing Sri Vijay Kumar T.N., files acknowledgement of having paid the costs. Full stop. He also submits that, Land Counsel also submits that the office objections were complied. Full stop. Registered to verify. Full stop. In case office objections are complied, comma, office to send notice to respondents 1 and 2 on furnishing the requisites. List on 11th November.
Serial number 12, Tanuja M.V.
The appellant. As directed by this honorable court, I have made the parties, my lords, respondent number.
But as per office endorsement, you have not complied the office objections.
By the time I filed the IA, the office has not stated those objections, my lords. Those are all small objections. I'll remove those objections, my lords. And meanwhile, tomorrow is the case before the trial court, my lords, execution. And delay of 48 days is there. Kindly, I may be permitted to take notice on the trial court advocate who is appearing for the petitioner.
There are a number of objections, Amma.
File only came after 4 days, my lords. Yeah, even before I filed the IA, the next day the file has come to the scrutiny branch.
Let the office objections be complied. Srimati Tanuja MB.
My lords, meanwhile, before the trial court execution.
The office objections. Full stop. Time for a week is granted.
My lords, 2 days is enough, my lords. 2 days I'll comply those objections.
Time for 2 days, seeks 2 days time to comply the office objections. Time as prayed for is granted. List on 25th September.
Tomorrow, a case is there before the trial court, my lords, so that I may be permitted to take the notice.
File the appeal belatedly and you have not complied the office objection.
My lords, I undergone the art surgery.
Yes,
I have stated the reason.
Yes, please comply the objection. Yes.
25. Serial number 13, BC Shivannegowda.
Yes, we have filed the application. So far, order has not been passed. Therefore, I request your lordship to grant another 4 weeks time to produce it.
Land Counsel Sri B.C. Shivannegowda seeks time for 4 weeks to file amended copy of the impugned order.
Today, connected matter is also posted in serial number 22.
File corrected copy of the impugned order. Hence, list on 29th October.
Serial number 22 also connected to this.
Yes,
Arranging of same, common judgment. 4993. 24, 22 serial number.
22 also same. Yes.
29. Serial number 14.
My lords, I'm
Harish Kannar.
for the appellant, my lords. My lords, there has not been grace period given so far as the since the judgment dated 23/5/2024, and we have applied for the copy in the subsequent next day itself, my lords, 24/5/2024. So 30 days usually will be given. So we did not file condemnation of delay through an IA, my lords.
File an application.
Please. I'll file the IA so far as the condemnation of delay, my lords.
As per office endorsement, the delay is 1 day. You file an application for condemnation of delay of 1 day.
Grateful. I'll do that itself.
Sri Shreyas in representing Sri Harish N.R. Land Counsel on record for the appellant seeks time to move an application for condemnation of delay in filing the appeal. Hence, stand over to 1st October.
Deeply obliged, my lords.
Serial number 15, B Pradeep.
For appellant, my lord, press 2 weeks time, my lords, to comply office objection, my lord.
Sri Mallikarjun Reddy representing Sri Pradeep B. Land Counsel on record for the appellant seeks time to comply the office objections. Full stop. Time for 2 weeks is granted. Stand over to 21st October.
Please, my lord.
Serial number 16.
16, my lordship, we have complied office objection regarding court fee, my lordship. First office objection number 1, my lordship. We have paid court fee, my lordship. Second
For office endorsement, you have not complied the office objection.
please, my lord. Second objection, my lordship. Company name, my lordship, the manager, Liberty General Insurance.
You comply the first objection.
I have complied, my
lord.
lordship. I have complied. Yesterday itself, I have complied. I have acknowledgement.
What about the second objection?
My lordship, second objection, the trial court made party, my lordship, insurance company name regarding insurance company name, my lordship. The manager, Liberty General Insurance Company Limited. But we made party name Liberty General GIC Ltd. My lordship. Instead of General Insurance Company Limited, we mentioned shortly GIC Ltd. That is the office objection.
Where you have mentioned short.
My lordship, as per appeal memo, my lordship. Appeal memo, appellant name, my lordship. Between the manager, the Liberty GIC Ltd.
Yes.
That is the office objection, my lordship.
Heard Sri Mallikarjun Reddy, who represents Sri Pradeep B. Land Counsel on record for the appellant. Full stop. So far as office objection number 1 is concerned, Kamal Land Counsel submits that court fee has been made good. Full stop. Proof that effect is also filed. Take that slip. Your good name, Amma? Next, keep it in the record. Full stop.
File counter ಅಲ್ಲಿ
ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ.
ಇದ್ರಲ್ಲಿ ಪಿನ್ ಮಾಡ್ಕೋಬೇಕಾ?
What did you write? Proof that effect is also shown. Full stop. Next. Regarding the second objection, that is the name of the appellant, Kamal and counsel states that the appellant is Liberty General Insurance Limited, and it is shown in the short form as Liberty GIC Limited in the memorandum of appeal. Full stop. Record discloses justification in the submission thus made. Full stop. Thus, the office objection number 2 is overruled. Next.
Insurance company challenging my lordship, negligence my lordship. Insurance company filed appeal, delay in filing appeal my lordship. As per ground my lordship, accident has occurred on head and collision my lordship, middle of the road. But entire negligence fixed against to the appellant my lordship. This is partly respondent also is liable to negligence my lordship. In entire negligence fixed against to the insurance company my lordship. That is we have filed challenging the appeal my lordship. Accident occurred middle of the road my lordship, head and collision.
A2 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Additional Motor Accidents Claims Tribunal Puttur in MVC 650 of 2021 dated 30th January 31 2024. Full stop. Learned counsel Sri Mallikarjun Reddy submits that though the claimant was also at fault and he contributed for the accident to occur, the tribunal fastened entire liability upon the petitioner appellant and therefore an appeal is filed. Full stop. Learned counsel thereby seeks to stay the operation of the impugned award. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Next. Thus, the operation of the award that is passed by the Additional Motor Accidents Claims Tribunal Puttur in MVC 650 of 2021 dated 30/1/2024 shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount before this court along with accrued interest, 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Full stop. In case such deposit is not made within such period, the petitioner appellant would be at liability to deposit entire award amount along with accrued interest within a period of 4 weeks thereafter. Full stop. Next, on such deposit, registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Next, issue notice to respondents in the appeal as well as in IA 1 of 2024 and 2 of 2024 on furnishing the requisites. List on 19th November.
Much obliged.
Serial number 17, hearing on IA, Ramesh KR, PV Raju.
For respondent.
The claimant appeal. The previous date, my lord, dishonorable court directed the respondent to file an objection. But they are not filed an objection
My
to
lord,
IA.
Delay may be condoned, my lord. We have gone through the application. On subject to, they are not entitled for interest, my lord.
You filed the appeal seeking enhancement.
Please, my lord. Only one simple ground, my lord, and that is the ECA matter. In the year 2011, my lord, accident was occurred. My lord, the income was taken 4,000, 5,000. My lord, as per the amendment, my lord, 2010 amendment, the appellant deceased was entitled for 8,000. It is the only one ground.
Heard. IA 1 of 2024, 1 of 2021 is filed seeking the court to condone the delay of 999 days in filing the appeal, in preferring the appeal. Full stop. Heard Sri Ramesh KR,
Sunil KN, my lord.
Sri Sunil
KN.
KN, who represents Sri Ramesh KR Land Council on record for the petitioner's appellants. Full stop. Also heard Sri
PS
PS
Jagdish.
Jagadish, Land Council, who represents Sri PB Raju, Land Council on record for respondent number 2. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the grounds urged, the delay as prayed for is condoned. Full stop. However, the petitioner's appellants will not be entitled for any interest over and above the amount that is awarded by the employees, by the Commissioner of Employees Compensation, if any, granted by this court through the judgment in the appeal for the period of delay of 999 days. Next number, final order. Next. Heard Sri Sunil
KN.
KN, Land Council, who represents Sri Ramesh KR, Land Council on record for the appellants, as well as Sri HD Jagadish, PS Jagadish, Land Council, who represents Sri PB Raju, Land Council on record for respondent number 2. Next, challenge in this appeal is the order that is rendered by the Commissioner for Employees Compensation, CERA, in ECA 22 of 2014, dated 16/6/2017. Full stop. The undisputed facts of the case are as under. 1. The deceased Basavaraju, within brackets, hereinafter be referred as the deceased for brevity, was the employee of
First respond.
first respondent. Full stop. Next.
My lord, he was claiming
The deceased died during the course of employment under first respondent. Next. The first claimant.
First claimant is the mother.
Is the mother, comma, the
2
second
and 3 are the
claimant
brothers.
is the father.
No, my lord, brothers.
The second claimant is the second claimant is the
Brother
brother, and the third claimant is the sister
of the deceased.
of the deceased. Next. Making the on hearing, Land Council Sri
Sunil KN.
KN, Land Council for the appellants, and Sri HD Jagadish,
PS Jagdish.
S. Jagadish, Land Council for respondent number 2, the substantial question that arises for consideration in this appeal is as under. Whether the Commissioner for Employees Compensation is justified in taking the monthly, justified in considering the monthly income of the deceased as rupees 5,000 per month. Full stop. Next, Land Council, Sri Sunil for appellants submits that the accident occurred in the year
2011, my lord.
Full stop. By the amendment that brought out
And 31st/5/2010 after amendment.
on 31/5/2010
10.
to the Employees Compensation Act, comma, the notional income is required to be taken as rupees 8,000 per month. Full stop. And therefore, the tribunal ought to have taken the notional income as rupees 8,000 per month while determining the compensation. Full stop. Land Counsel Sri Jagadish did not raise any objection.
No, I have raised objection.
What objection?
The judgment passed by the ECA is just and proper.
Land Counsel Sri Jagadish HT,
PS,
those
PS.
states that the amount awarded as compensation is justifiable, comma, did not deny the fact that in the light of the amendment brought out, comma, the notional income is required to be taken as rupees 8,000 per month. Stop. Thus, taking the notional income as rupees 8,000 per month, comma, deducting 50% of it and applying the proper factor, that is 219.95, comma, the compensation which the appellants are entitled to will be
8,79,800.
8,79,800
Please, ma'am.
will be rupees 8,79,800. Full stop. Therefore, the point taken up for discussion is onset holding that the income is required to be considered as rupees 8,000 per month. Full stop. Thus, the entitlement of the appellants for compensation is rupees 8,79,800. Full stop. Therefore, the appeal is disposed of with the following order.
Regarding interest, my lord, 9% was awarded before the trial court.
It should be 12%.
Please, ma'am.
Next, during the course of submission, Land Counsel for the appellants also raised a contention with regard to the rate of interest. Full stop. The tribunal awarded the Commissioner for Employees Compensation awarded compensation with interest at the rate of 9% per annum. Full stop. However, the interest that is required to be awarded is 12%. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The appeal is allowed.
Regarding interest is concerned, my lord, the order passed by the trial tribunal also.
Yes, it will be modified.
Please, ma'am.
The appeal is allowed. Full stop. The compensation that is granted by the Commissioner for Employees Compensation, CIRA, through orders in ECA 22 of 2014 dated 16/6/2017 is enhanced from rupees 5,47,875 to
7 lakh.
rupees 8,79,800. Next, the entire award amount carries interest at the rate of 12% per annum from the date of petition till the date of deposit. Full stop. The second respondent is directed to deposit the entire compensation immediately.
But delayed period, the appellant is not entitled.
With interest. However, as per orders in IA 1 of 2021, the appellants are not entitled for interest for the period of delay of 999 days.
Obligation. Instead of immediately, my lord, within 6 weeks we'll deposit.
The second respondent is directed to deposit the entire award amount within a period of 6 weeks.
Please, ma'am.
From the date of receipt of copy of this.
Serial number 18. 18 Geeta R. Gopala Krishna N.
Yes, I am for the appellant.
ಅವ್ರೇನು ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಒನ್ ಆಫ್ ದ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ. ಹೌದು R3 ತಗೊಂಡಿಲ್ಲ.
18.5. We are not third time. We are not-
Serial number 18. 18, it has come for condonation of delay. It is connected with their appeal. The other insurance company has also filed an appeal. It is connected with us 18.1 and 18.2 by the claimant, my lords. And again, 18.3 is my appeal connected with an insurance company, other insurance company appeal and a claimant appeal, my lords. As far as 18.3 is concerned, we have already made, deposited the 50% award amount. I would furnish that memo. And in 18.4, claimant has to take steps to R3, my lords.
Let us see. In MFA 2035 of 2020-18, any objection for condoning the delay?
No objection.
Ma. Right paragraph by some for each thing. IA 1 of 2022. In MFA 2035 of 2022 is filed, seeking the court to condone the delay of 7 days in filing the appeal. On hearing both sides and having perused the contents of the affidavit given in support of the petition, the delay as prayed for is condoned. Next page. Next up, 356. Any objection for condoning the delay in 18.1 matter?
No objection.
IA 1 of 2020 in MFA 356 of 2021 is filed, seeking the court to condone the delay of 42 days in filing the appeal. Full stop. On hearing both the learned counsel, on hearing on both sides, and upon perusing the affidavit given in support of the petitions, having considered the ground urged, the delay as prayed for is condoned. Next. Next paragraph. Learned counsel Srimati Geeta R. For appellant in MFA 2019 of 2022 submits that acknowledgement of having deposited 50% of the award amount is filed. Registry to verify. Next paragraph. What about notice to R3 in 18.4?
With your lordship's kind leave, it was my submission that I would file the memo for having depositing the amount, my lords. Have not yet, we have deposited before the tribunal. That memo I would.
Why you could not file, Amma? Then.
No, connected matter, last hearing date I had filed it, my lords. That memo, I see that it's missing from my file. I would file it, my lords.
Ma, you remove that.
Kindly weeks time may be given, my lords.
Done counsel Srimati Geeta R. For appellant in MFA 2019 of 2022 submits that seeks time for a week to file acknowledgement of having deposited 50% of the award amount. Full stop. Time as prayed for is granted. Next.
18.4. R3 is.
Furnish the requisites.
No. 18.4, R3 is the
appellant in 18.5.
Mhm.
Notice author may be dispensed that case.
You are appearing for that part,
Claimant, both are claimants. Rider and pillion rider.
but notice has to go because you cannot file wakalat. You are for the appellant in this matter.
Right.
Land Counsel Sri Gopal Krishna N seeks time to furnish the requisites for issuance of notice to respondent number 3 in MFA 3780/2022. Full stop. Time for a week is granted. Full stop. On furnishing the requisites, office to send notice to respondent number 3. List all the appeals on 13th November.
Much obliged. Grateful, my lords.
Serial number 19. P. Mahadev Swami, Mohan Kumar T, for respondent.
It's a paper appellant, my lord. The claimant appeal, my lord. The respondent number 3 is the necessary party. I file application order by rule 20, paper publication only.
IA 1 of 2024 is filed. Seeking the court to permit service of notice upon respondent number 3 by way of substituted service. Full stop. Next, Sri P. Mahadeva Swami for petitioner's appellant submits that despite of sending notice to respondent number 3 several times, the same could not be served and therefore this application is moved for paper publication. Full stop. Having considered the submission thus made, the petition is allowed. Next. Publishing, whether this is
No, my lord, I have permitted to publish the paper.
Fosa Diganta.
Vasa Diganta.
Fosa Diganta. Is it in circulation?
Circulation in all over Karnataka, my lord.
Bangalore local.
Yeah, Bangalore.
Is it a notified?
Local.
We don't have the notified newspapers. No. Publishing Fosa Diganta daily newspaper, Bangalore edition, directing respondent number 3 to take notice about the pendency of the pendency of the appeal against him and to make his appearance. Full stop. Paper publication to be taken within 2 weeks. Indicating the date of hearing as 22nd, this is 2020. Date of hearing as 5th November.
Paper publication within 15th November.
Within 2 weeks.
Much of them.
Serial number 20.
For appellant, my lords.
Gita R.
Appearing for R4.
Kindly pass over.
Why?
Senior is held up in others.
My lord, they've made an application seeking release of the amount in deposit. Already the tribunal has held the claimant is negligent to the extent of 25%. Against that order, I am before this honorable court questioning the judgment on the ground of negligence. The tribunal ought to have.
Contention is that entire negligence is.
No, not entire negligence. Whatever the amount I have deposited, in that 50% may be released, my lords.
Senior is held up in others. Kindly pass over.
What is your case?
The claimant was driving a.
Let him shut.
Yes.
What is your case? Yes, what is your name, Mr. Counsel?
Bharat,
Mr. Bharat, before entering the court hall, you should be thorough with the case file.
sorry.
Huh?
Sorry, ma'am.
Otherwise, for the entire journey of an advocate, your representation would be senior is held up in another court. You should go through the record. At least you should be in a position to submit the facts of the case. We'll pass over the matter.
Pass over. Serial number 21. B. Pradeep Rangegowda NR for
I am for
respondent.
appellant, my lordship. I appeal in filing my lordship, delay in 29 days delay in filing appeal my lordship. Connected matters, another 4 matters is remaining, my lord. Same arising out of accident, my lord. I am giving list of the
IA 2 of 2023 is filed, seeking the court to condone the delay of 29 days in filing the appeal. Heard, Sri Mallikarjun Reddy, Land Counsel who represents Sri Pradeep B, Land Counsel on record for the petitioner appellant. No representation on respondent side on call.
I appear for respondent number 3, my lord. I appear for respondent number 3.
No representation for respondent number 1 on call. Full stop. Sri S.V. Hegde Mulkun, Land Counsel for respondent number 3 appears through VC. Any objection for condoning the delay?
No objection, my lord. It may be condoned. It may be condoned.
Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the grounders, the delay as prayed for is condoned. Next Veram. Sri Mallikarjun Reddy submits that MF, how many appeals are there?
total 6 cases, my lord. I have given list of.
Also are connected to the present appeal. Seeks to list all the matters on the same day. Full stop. In the light of the submission thus made, comma registry to verify and to list the present appeal along with the MFA so and so on 15th November.
Meanwhile, call for TCR, my lord.
Let the records be
Please,
received.
madam.
Let all the cases.
Please, my lord.
All are from same judgment.
Please, my lord. Come on, judge.
Call for the records from the concerned tribunal in the meantime.
Serial number 22 adjourn. 23 Sushmita.
We have opened this case, my lord. Filing memo for dispensation of notice to R1, my lord.
Land Counsel for the appellant, Ms. Susmita G, files a memo seeking dispensation of notice upon respondent number 1. Full stop. Land Counsel states that as respondent number 1 remained ex parte before the tribunal, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
R2 is HDFC Ergo General.
May I take notice?
Sri D. Vijay Kumar is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri D. Vijay Kumar. Next one.
Much obliged.
List on November 19th.
Much obliged.
Serial number 24.
Appear for applying this case, my lord. Filing memo for dispensation of notice to R1. Ex parte in MICT, my lord.
Land Counsel, Ms. Susmita G. Land
My lord,
Counsel for
universal
appellants,
sum for
Ms.
accept notice, my lord.
Ms. Susmita G. Yes, Mr. Counsel, what is that you are telling?
Really, sir.
Universal sum for accept notice.
Universal.
What did you say? What did you write? Susmita G, appellant, Ms. Susmita G files memo seeking dispensation of notice upon respondent number 1. Full stop. Land Counsel submits that as respondent number 1 remained ex parte before the tribunal, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensary, however, at the risk of the appellant. Full stop. Sri Rajendra Hegde Mulkund is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Rajendra Hegde Mulkund. List on same date, 19th November.
Much obliged.
Serial number 25. Harish NR.
My lords, I'm for the appellant, my lords. This is a case of death and I'm for the enhancement of compensation, my lords. So far as the R1 is the borewell lorry vehicle owner and the policy of insurance exists at the time of accident, my lord. So therefore, I'm filing for dispensation of memo, my lords.
Yes, file.
Memo is going. Nimsh.
Sri Shreyas in representing Sri Harish NR Land Council on record for the appellant
Appellant.
files memo seeking dispensation of notice upon respondent number 1. Full stop. Land Council submits that as liability is fixed upon respondent number 2, comma, notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next.
National insurance, my lords.
Yes. Sri Ashok and Patil is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Sri Ashok and Patil. List on 20th November.
Grateful, my lords.
Serial number 26.
Again, I'm for the appellant, my lords. This is a case of injury, my lords. I'm filing a memo for dispensation of R1, R2, my lords, who are the owner and policy holders of the Hyundai offending vehicle, my lords. So
Why the notice has to be dispensed with?
the policy is existing at the time of insurance, my lords. Reliance General Insurance is the respondent 3, my lords.
Sri Shreyas, yes.
And please.
In, representing Sri Harish NR Land Council on record for the appellant files memo seeking dispensation of notice upon respondents 1 and 2. Next, Land Council submits that as respondent number 3 had issued policy of insurance and with suit subsisting by the date of accident, comma, respondents 1 and 2 are formal parties. Full stop. Having considered the submission thus made, comma, notice to respondents 1 and 2 stands dispensed with, however, at the risk of the appellant. Next.
Reliance General Insurance, my lords.
Sri B. Pradeep is called upon to accept notice for respondent number 3 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat will be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri B. Pradeep. List on 20th November.
Deeply obliged, my lords.
Serial number 27, D. Vijay Kumar.
My lord, I am for the appellant, my lord. My lord, this appeal is by the Reliance General Insurance Company. My lord, as far as certified copy is concerned, my lord, we have filed the certified copy in the connected appeal filed in MEC 1116/2019.
But without looking at the certified copy of the award, we cannot pass any orders of stay, Mr. Counsel.
My lord, that is why I filed a memo for dispensation.
We cannot dispense. We can dispense with, but we cannot give an interim relief.
My lord, then, my lord, we are, since my lord, both are kindly post connected matter, my lord.
Land
Kindly
Counsel
post.
Sri T. Vijay Kumar submits
Number
that
ready,
MFA so-and-so is connected to the
connected appeal
present
ಇದೆ.
appeal.
Number ಹೇಳಿ sir. MFA numbers.
6180/24 FR number.
No, Mr. Counsel. we
1
cannot-
minute, we are verifying, my lord, we'll give the number.
Next.
Kindly post.
Yes.
ಬೇಕಾಗಿದೆಯಮ್ಮ?
Get the number. We'll pass over the matter.
I'll give to the court officer, my lord. I'll give to the court officer.
Matter is passed over.
Pass over ಆಗಿದೆ.
Much obliged, much obliged. Much obliged.
Serial number 28, Prasanna VR.
Owner's appeal, my lord, challenging the fixing of liability on him and dismissal of claim petition against the insurance company, respondent number 3, my lord. On the ground that the vehicle of the appellant has no valid insurance policy at the time of accident, ignoring the fact that the accident is was happened at the time of COVID-19 pandemic, my lord. And there was a direction circular issued by the central government with respect to extension of time for renewal of documents relating to the motor vehicles, my lord, which fact is not considered by the tribunal, my lord. As such, I have filed the application for stay also. The
Srimati Prasanna VR.
Yes, my lord.
Land Counsel for the appellant. Next, IA 1 of 2024 is filed.
ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ.
Lakshmi Devi K. For the Prasanna.
Srimati Lakshmi Devi K. Land Counsel who represents Srimati Prasanna VR. Land Counsel on record for the appellant. Full stop. IA 1 of 2024 is filed seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bantwal, in MVC 1285 of 2020, dated 2/5/2024. Full stop. Land Counsel Srimati Lakshmi Devi contends that the petitioner appellant is the owner of the auto rickshaw.
No, Maruti Omni car, my lord.
Is the owner of the
Offending.
Maruti Omni car which is involved in the accident. Full stop. Land Counsel submits that the tribunal exonerated respondent number 3 insurance company from liability and fixed entire liability upon the petitioner appellant. Full stop. Land Counsel submits that as per the guidelines issued by the central government, the policy stood in force by the date of accident. However, the said fact was not considered by the tribunal. Full stop. Land counsel thereby seeks to stay the operation of the impugned order. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted, however conditionally. Full stop. Thus, the operation of the award that is passed by the Motor Accidents Claims Tribunal Bantwal in MBC 1285 of 2020 dated 2/5/2024 shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, the registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Next, issue notice to respondents 1 and 2 in the appeal as well as in IA 1 of 2024 on furnishing the requisites. Next.
R3 is the national insurance company.
What did you write? On furnishing the requisites. Next. Srimati H.R. Renuka is called upon to accept notice for respondent number 3 and file wakalat subject to entrustment of the case otherwise by respondent number 3. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Srimati H.R. Renuka. List the matter on 21st November.
With your lordship's kind permission, my lord.
Yes, Mr. Counsel.
My lord, the previous matter, my lord, serial number 27. My lord, this matter is connected with the 611/6/24. Your lordship yesterday stayed the matter, arising out of same judgment, accident, common judgment.
You want this matter to be connected with that matter?
Please, my lord. And that matter is stayed, my lord. In this matter also, my lord, I sought for stay.
Land counsel for the appellants appears to VC and seeks to list the matter along with MFA so and so.
Number
611/6/24.
Hence, register to verify
611.
and list present appeal along with
611/6/24. Tomorrow, my lord. Can it be
on
tomorrow?
the date given in MFA so and so.
My lord, this matter, then your lordship kindly
How
grant
can it
stay,
be,
my lord.
Mr. Counsel? Yes.
My lord, both are arising of the same common accident, common
But you
judgment.
have to file when you want to add an order of stay in both the matters, you have to file the certified copies. Why
My lord,
why you could
my lord,
not
usually,
apply
my
the
lord,
certified
all
copy?
these years, my lord,
Yes,
so
yes,
far,
file the
my lord, we are
certified
filing
copy.
a
Next.
dispensation application
On
only.
obtaining the certified copy, you can move a court slip. Next. On that day. On the date. given to-
along with them.
Yes.
Serial number 29, Satish Ati, Ravi Samprati.
Pattern matter, pass on matter. Ravi Samprati ready there.
Pass over.
Pass over. Serial number 30 for dismissal, D. Vijay Kumar, A. Hanumantappa.
I am for the appellant. I am ready, my lord.
Respondent, my lord. Only one submission, my lord. Sorry, my lord, I bring the wrong file today, may have taken up tomorrow, my lord. Sorry, my lord.
More than 10 times this matter is posted for final hearing.
Last time ತಾವೇ ಇರಲಿಲ್ಲ ಸರ್ 2 ಸತಿ ತಾವು ಇರಲಿಲ್ಲ ನಾನಿದ್ದೆ ಪ್ರೆಸೆಂಟ್ tomorrow, my lord.
Please, my lord.
T. Vijay Kumar, Land counsel for the appellant appears through VC and reports ready. Full stop. However, Sri Hanumantappa A, Land counsel for respondent number 1, appears physically and seeks time.
Allah, his colleague, my lord, he is not Hanumantappa.
Mahesh.
On the other hand, Sri Mahesh representing Sri Hanumantappa A, Land counsel on record for respondent number 1, appears physically before this court and seeks time. Full stop. Therefore, remove the matter from the caption for dismissal and list under the caption admission on 5th November.
Serial number 31, HR Renuka, Gopala Krishna N.
Sorry, my lord, I could not be present. My lord, in this case, we have called me to question the issue on negligence, my lord. I think the TCR is required, my lord.
Admitted in
611.
yes. Heard, Srimati Renuka HR, Land Counsel for the appellant, as well as Ms. Susmita G,
Respondent one.
Land Counsel who represents Sri Gopal Krishna N, Land Counsel on record for the respondent. Admit, call for the records from the consent tribunal, list the matter under the caption final hearing on 24th October.
Much obliged.
Serial number 32, AN Krishnaswamy, DP Prasanna for R1.
For respondent one.
Rebuild the file I have misplaced at my office. Trying to get it from my learned friend.
Yes.
Kindly have it 10 days.
Attachment documents. Yes, we'll admit the matter.
Okay.
Heard, Sri N. Krishnaswamy, Land Counsel for the appellant, as well as your good name, Mr. Counsel.
Prasanna DP. Prasanna DP.
As well as Sri DP Prasanna, Land Counsel for respondents 1 and 2.
Satish Kumar M.
Admit. As well as Sri Satish Kumar, Land Counsel who represents Sri DP Prasanna, Land Counsel on record for admit. Records received. Admit, list the matter under the caption final hearing on 21st October.
Serial number 33, BC Sitaram Rao.
Malaj, I appear for
Respondents,
in the
served
matter.
unrepresented.
Malaj, there are two more appeals connected to the same accident, Malaj, which needs to be called along with Malaj.
Sri Anup Sitaram Rao appears through VC and submits that MFA
1753 and 1756,
of
2021.
are connected to the present appeals, seeks to list all the matters on the same day. Full stop. In the light of the submission thus made, registry to verify and to list the present appeals along with MFA so and so on 25th October.
Much obliged.
Serial number 34, KM Somashekar, Ravish Bending.
Appear for the appellant, my lord, records are required. 23/2024, the sample court call for records, my lord.
Received. I'm ready, please.
Lord, it's a case of injury, my lord. Lord, it may be taken up 2:30, my lord. Once I go through it, records.
Yes, possible.
2:30 ನಂಗೆ quarter 10 pass over kindly accommodate some time, please. I will come later immediately after completion of that case, please. 2:30 quarter 10 ಒಂದು pass over just now. Or tomorrow, day after tomorrow, please.
We'll hear the matter.
Please.
Serial number 35, Giri Mallaya.
Lords, I beg to appear for the corporation, my lords. Lords, in the connected matter, I will take out the process today itself, my lords.
What is it?
My lords, in 5440, I'll take out process today itself, my lords.
This is 2021 matter, Mr. Counsel.
Please, my lords. I'll take out notice. I'll pay the process today itself, my
The
lords.
Karthikeyan BS, Land Counsel for the appellant in MFA 5440 of 2021 submits that requisites will be furnished during the course of the day. Full stop. On furnishing the requisites, office to send notice to respondent number 3. List both the appeals on 29th October.
Grateful.
Much obliged.
Serial number 36, Gopal Krishna N, Kailash Shankar for R1.
I'm for respond number 2, Your Appear for Lordship. appellant in this case, my lord. Lord, today there's slight inconvenience, my lord. Slight inconvenience today, my lord. Kindly may have it next week, any day.
Miss Susmita G, Land Counsel representing Sri Gopal Krishna N, Land Counsel on record for the appellant seeks time. Hence, stand over to 25th October.
Much
Obliged,
obliged.
Your Honor.
Serial number 37, Gurudev Prasad KT, Ashok N Patil for R1.
Respond. I am ready.
Yes.
It's a case of death knell. Parents are the claimants. He was working in Intelent Global Service Private Limited, and he was getting salary of rupees 15,580.
Payments are parents, huh?
Parents. And of course, I have produced a salary slip, but I have not examined the employer of the deceased. My request is notional income may be taken and matter may be disposed of. 2000, the accident is dated 31/3/2019. Deceased was 25 years. Para 14 and 15.
So the age was 25 years.
25 years. For the year 2019, 14,000. Multiplier is 18. 40% test.
14,000 is the notional income.
Yes. 40% test.
The tribunal has not granted any
Illa,
vote
but
to
no.
class of consortium.
Filial consortium.
Yes, Mr. Ashok?
Please, Milords. That's my only submission is this, Milords.
Yes.
The Milords, there is no denial of the fact that the accident occurred on 31/3/2019 and the notional income. But in the absence of Milords, the examination of the employer, the bank statement would indicate that 12,000 is therefore Milords, it is rightly taken. And Milords, the interest awarded is at 9%, Milords. If any enhancement, Milords, the interest, Milords, on the enhanced amount may be 6%.
But it goes to show that he was earning 15,580. If the pay slip is produced.
12,000 is after deduction.
So we'll take it as 14,000.
Yes, please.
So loss of dependency comes to rupees 21,16,800.
Yes,
15,000 towards funeral expenses, 15,000 towards loss of estate, 40,000 towards loss of consortium. Total 21,86,800.
Father and mother, both, father and mother, both 80,000.
No, yes. Third, Sri Gurudev Prasad KT, Land Counsel for the appellants, as well as Sri Ashok N. Patil, Land Counsel for respondent number 1. The parents of Ayub Ahmad Khan, who died in a road traffic accident that occurred on 31/3/2019, filed a petition claiming compensation of rupees 80 lakhs in total. Full stop.
Sorry, my matter is reaching the
You
court
can
of
get this. The Motor Accidents Claims Tribunal Bangalore, which dealt with the case as MVC 2429 of 2019, passed orders on 21/11/2019, granting a sum of rupees 18,45,000 as compensation. Full stop. Projecting a version that the said amount is gross, the claimants are before president. Next. Arguing the matter, Sri Gurudev Prasad KT submits that the deceased Ayub Ahmad Khan, within brackets hereinafter be referred to as the deceased for brevity, was working at Intelnet Global Service Private Limited and was earning rupees 16,000 per month. Full stop. Though sufficient proof with regard to the educational qualification of the deceased, his occupation and earnings were produced, the tribunal failed to take the actual earnings of the deceased, that is rupees 16,000 per month. Full stop. The tribunal took the notional income as rupees 12,000 per month and awarded a meager sum as compensation. Full stop. Land Counsel contends that the accident occurred in the year 2019 and for the relevant period, the Karnataka State Legal Services Authority is taking the notional income as rupees 14,000 per month, and at least the set figure should have been considered by the tribunal. Full stop. Land Counsel also states that the tribunal failed to award any amount towards loss of consortium. Full stop. Land Counsel states that the appellants, being parents of the deceased, are entitled to compensation under the head loss of consortium. Full stop. Next paragraph. The submission that is made by Sri Ashok N. Patil, Land Counsel for respondent number 1, on the other hand, is that though the appellants produced documents relating to the occupation and earnings of the deceased, they did not choose to examine the employer of the deceased and establish the genuineness of those documents. Full stop. However, Land Counsel Sri Ashok N. Patil did not object and did not raise any objection for taking the notional income as rupees 14,000 per month as sought for by the learned counsel for the appellants. Full stop. Also, the notional income to be taken as rupees 14,000 per month is justifiable. Full stop. Thus, taking the notional income of the deceased as rupees 14,000 per month and without disturbing the other parameters, that is adding of 40% towards future prospects, deducting 50% of the actual earnings towards personal and living expenses of the deceased, which he would have incurred had he been alive, as he was a bachelor by the date of accident, and applying the appropriate multiplier 18, the amount which the appellants are entitled to under the head loss of dependency is as under the tabular form. Notional income 14,000 per notional income per month 14,000, annual income 1,68,000, add 40% towards future prospects 2,35,200, deduct 50% towards personal and living expenses 1,17,600, apply appropriate multiplier 18, 21,16,800. Full stop. Next, thus the compensation which the appellants are entitled to under the head loss of dependency is 21,16,800. Full stop. Together with the said amount, the appellants are entitled to rupees 15,000 towards funeral expenses and 15,000 towards loss of estate. Next, as rightly contended by Sri Gurudev Prasad Ketil and counsel for the appellants, the tribunal failed to award any amount towards loss of consortium. Full stop. The appellants, being the parents of the deceased, are entitled to rupees 40,000 towards loss of filial consortium. Full stop. Thus, the total compensation which the appellants are entitled to is as under. Loss of dependency 21,16,800, funeral expenses 15,000, loss of estate 15,000, loss of consortium 40,000. Total 21,86,800. Full stop. Thus, in the light of the foregoing discussion, the justifiable sum which the appellants are entitled to as compensation is 21,86,800. Full stop. Thus, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is awarded by the Motor Accidents Claims Tribunal, Bengaluru, through orders in MBC 2429 of 2019, dated 21/11/2019,
Sir, delay.
is enhanced
Delay.
from 18,45,000 to rupees 21,86,800. Full stop. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The deposit. Respondent number 1 is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop. The apportionment made applies to enhanced sum also. Full stop. On deposit, the appellants are permitted to withdraw their respective sheets.
Please.
Serial number 38, adjourn. 39, Suma K. Lalita PM for responding.
PCR may be required in this case.
Heard. Ms. Suma K, learned counsel for the appellants. Admit. Appellants. No representation on respondent side on. Admit. Call for the records from the consent tribunal. List the matter under the caption final hearing on 7th November.
Serial number 40. Girish Baldare, G. Lakshmish Rao for responding.
There are two appeals.
One is challenging the issue of negligence and another by the claimant for seeking for enhancement.
Yes, we'll admit both the appeals. Ready for hearing?
Yes, my lord.
Yes,
Ready.
please proceed.
Ready?
Yes,
Records are secured, my lord.
yes.
Lord, the accident is on 9/7/2017. The vehicles involved in the accident is a KSRTC bus and the bike. Lord, the case made out by the claimant is that the bus was on an upgradient going towards Ballupet. The bike was in an opposite direction, moving towards Kodlipet. The accident took place in a curvature. It is the case of the respondent corporation, the appellant herein, that since the bus was in an upgradient, bus was moving slowly. Since the accident took place in a curvature, there is no collision between the bike and the bus. There is no damage to the vehicle. It is a self-fall accident. By looking at the bus, since it is a curvature, he was shocked and he lost control and he fell down and he sustained injuries. It is not because of the bus hitting or bus dashing the bike the injuries were caused. Therefore, KSRTC bus was not at all involved in the accident in question. Therefore, KSRTC bus is not liable for any compensation. That was a precise case made out by the corporation before the tribunal. However, the tribunal did not consider my contention, proceeded on the basis of the charge sheet, and certain reasonings or certain findings are given. That appears to be not satisfactory, not happily worded. I will take your lordship to the relevant portion of the judgment which is being dealt by the tribunal.
There are 13 to 15 men.
Lord, my defense is at paragraph number 15, the appreciation of my defense by the tribunal. Now coming to the, if your lordship permits, my lords, I will read.
Yes, yes.
Now coming to the other defense, there is absolutely no contact or collision between the vehicles, is without any substance. The respondent himself has produced some photographs to show that the bike fell down and bus was also standing. Much has been attributed about the fact that the bus has not suffered any damages. Admittedly, bus is a heavy vehicle and a small touch to the bike also causes the accident, and there may not be any damages to such heavy vehicle. Apart from that, the passengers of the bus was also examined even after referring the same in the written statement. The bus was inspected by the concerned RTO only on 14/9/2017, as could be seen from Exhibit P11, whereas Exhibit P5 shows damages are caused to the motorbike. The respondent has contended that the passengers of the bus driver and conductor have tried to help the petitioner on humanitarian grounds, which was misused. In order to believe such facts, there is no acceptable evidence. None of the passengers are examined in order to substantiate such allegations. Apart from that, the police documents clearly points out that the guilt on the part of the KSRTC bus driver. The KSRTC bus was stationed in the stop till the photographs are also taken. These facts show that the defense taken by the respondent in this regard is bald and vague. Viewed from any angle, there is absolutely no merits in the contentions taken by the respondent. The driver of the respondent has not chosen to file any counter case or made any effort to file a complaint stating that he has not committed any criminal act. The Maser produced before the court discloses that an accident took place on wrong side of the bus and the bus is expected to drive on a left side, but it has gone to the right side and caused the accident. There is no acceptable evidence to believe that in order to avert the accident, bus went to the right side of the road except self-serving statement of RW1. There is nothing available to believe the version of the respondent. On the other hand, petitioner's claim is based on the police document. The argument that the PW1 admitted about bus not touching the bike is without any merits. What petitioner admits is that front bumper never touched his bike. He never admitted that the bus never caused any accident. The police documents cannot be suspected in the absence of showing any special interest or animosity by the police against the respondent. Under these circumstances, the police documents can be relied upon to come to the just conclusion, and investigation in this case revealed that there is wrong committed by the bus driver and he is responsible for causing the accident. Exhibit P1 to P8 fortifies the evidence of PW1 and the evidence of RW1 in this regard cannot be believed in the facts and circumstances of the case. Accordingly, the petitioner is able to show that the accident took place due to rash and negligent driving of the respondent driver, as a result of which he has suffered injuries. The discharge summary, wound certificate and other document shows that the petitioner has suffered grievous injuries. Accordingly, issue number 1 is answered in the affirmative. Lords, I pause for a moment. Lords, the 4 observations are the findings which are against me that I am projecting before this court here. Firstly, my lords, the tribunal says only because that the vehicle is not damaged, one cannot jump into a conclusion that the accident has not taken place. Your Lordship may kindly appreciate the bus was in an upgradient. Admittedly, bus was in an upgradient direction. The bike was in a downgradient direction. My lord, the injured, the claimant himself admitted in the cross-examination that the bike has not touched the bus. I may,
RW1
my lords,
RW1 is the driver of the KSRTC bus.
is the driver, RW1 is the.
RW1 is the driver. We examined the driver. No, I am on the, my lord, I'm seeking permission to read a portion of an evidence in the cross-examination wherein which the claimant himself admits that his bike did not touch the bus.
PW1 evidence.
Yes, my lords, PW1.
Court office, PW1 evidence. One. Cross-examination is also examined.
Lordship
It's
gets
in
it.
Canada, my lord.
I'll translate it to.
Yes,
We'll take to the cross-examination portion, my lord, the first paragraph,
what does he say?
my lords. I will first read it Kannada and then translate it.
Need of reading, anyhow we can't understand.
My lord,
You translate it and submit.
my lords, what the claimant says is, ಬಸ್ಸಿನ ಮುಂಭಾಗ ನನ್ನ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಟಚ್ ಆಗಿಲ್ಲ ಎಂದರೆ ಸರಿ, ನನ್ನ ಕೈ ಆಗಿ ಅಪಘಾತ ಆಗಿದೆ. It means that it is true that the front portion of the bus did not touch the bike, but my hands are it has touched because of my touching the hand, the accident has taken place.
Further words ಹೇಳಿ. Further continuous cross examination. Further.
ಅದನ್ನ ನೀವು ಹೇಳಿ, that's I'm trying to make out a point that the bike did not touch the bus and therefore the KSRTC bus is not at all responsible for the accident. You know, this is the cross-examination part. He clearly admits that the bike did not touch the bus. So there is no collision between the bus and the bike. His main case is he pleaded before the court is that the bus collided with the bike and thereby the accident has taken place. So in the cross-examination, he clearly admits.
He stated during the cross-examination that the bike did not touch the bus.
Touch the bike, bus touch the bus.
Version is that bus touched the bike.
No. My lords, the next version is there must be some damage. If the bus touched the bike, there must be some damage to the bus. There is not even a simple damage. I have produced the IMV report before the court, and the IMV report says no damage has taken place. Let's see, IMV report, no damages found on the said motor vehicle at the time of my inspection. That is KA 19F3257 KSRTC bus. So it is an admitted fact that there is no damage caused. In the cross-examination, he admitted the bike did not touch the bus. So no collision. My humble submission before this court is that the bus has not touched the bike at all. Then, Lordship may kindly Spot Mazer. Lordship may kindly appreciate this Spot Mazer. Spot Mazer, my lord, it is with the exhibit P3. Along with the Spot Mazer, the spot sketch was produced. Lordship gets it, my lords.
Yes,
In the top portion,
yes.
The bus was an upgradient going towards Ballupet. Towards the right side is Ballupet. The bike was coming from a down gradient, it is going towards Hoskote Road, that is Kodlipet Road. Kindly see the spot of accident, my lords, which is in the extreme left side of the road. This is in curvature. When the bus was on its proper side, bus was moving on its left side. The accident has also taken place on a left side. When admittedly, my lords, the bus is not at all involved in the accident. The bus driver is not negligent in causing the accident in question. Suppose if the spot of the accident is in the middle of the road or on the right side, it is correct. But however, my lords, the tribunal completely misunderstood and misinterpreted the sketch and had come to a conclusion that the bus has gone to the right side.
Yes.
The observation which I just now I read it, my lords, with cost of repetition, at paragraph number internal page 10, the last paragraph, my lords. The Maser produced before the court disclosed an accident took place on the wrong side of the bus, and the bus is expected to drive on a left side, but it has gone to the right side and caused the accident. This is completely misunderstanding of reading of the evidence on record. Spot Maser and the sketch clearly reveals that the bus was on its correct side. It was on an upgradient. Then the bike driver had come to the extreme right, and by seeing the bus, he lost control and he fell down. The accident has taken place.
But charge sheet is laid against the driver.
Yeah, yes, my lord, I am saying, but only because that the charge sheet is filed against the bus driver. The question which I am posing for me is that can it be said that only because that the charge sheet is filed that the KSRTC bus driver can be held responsible? Because the accident speaks for itself. This is based on the theory of res ipsa loquitur theory.
Lawyer, what did you do when a wrong charge sheet is filed against your employee?
I have not challenged the charge sheet. My lords, the question is only because that the KSRTC has not challenged the charge sheet. When the record speaks for itself, this is a tertiary form, admittedly.
Yes, Mr. Counsel, when you are burdened with some monetary, you are fixed with some monetary liability, you are before this court.
Please, madam.
When your employee is booked under a wrong case, why you have not gone to his rescue? If that is so.
Lord, the accident has placed on 7/9. The charge sheet, the FIR was filed after 9 days.
Yes, why did you
After
file
9 days. I am not saying that the complaint could have been lodged. It's permissible. But having regard to the corroborative circumstances in which that we may have to appreciate. My lord, he fell down and it is because of the self-fall accident. He did not lodge a complaint and it is an afterthought thereafterwards that he thought that there may be some claim and therefore he goes and lodges an FIR before the court after 9 days. Charge sheet is filed against me, no doubt. I have not challenged the charge, it's an admitted fact. But my humble submission before this court, since this is a tertiary forum, independent of the charge sheet, by looking into the records which are placed before the court can go into it and the court can appreciate it.
Yes.
But suppose if the spot master is disbelieved, that's a different matter. When admittedly the spot master, he also relies upon the spot master. Spot sketch clearly says the accident has taken place on the extreme left side. The bus was on its proper side. The bus was on its proper side. You're assuming for a moment. It's a clear case of self-fall accident. No damage is caused to the bus. And therefore, I am specifically stressing on that spot sketch and the spot master that the accident has taken place. It is only due to the self-fall by looking into the bus in a curvature. He lost control and he fell down and the accident has taken place. Therefore, my lords, this is a clear case where, my lords, the negligence cannot be attributed on the KSRTC driver. So, one is self-fall accident, he lost self-control. The second is the FIR is filed after 9 days. It's an afterthought. And the spot master and the spot sketch clearly reveals that the bus driver is not involved in the accident.
Yes, Mr.
Even in the medical record, there is nowhere it is mentioned it is a accident caused to the driver of the vehicle due to self-fall. And even the medical record specifically speak about the manner in which accident has been taken place. In the discharge summary, it is clearly indicated two-wheeler collided with the bus. There is no word of self-fall as contended by my learned friend. And also after due investigation, after
investigation the charge sheet has laid against the offending vehicle with the driver of the bus. And also there is no attempt made by the driver or any authorities concerned to lodge the complaint against the rider of the offending rider of the motorcycle. And even they have not made an attempt to challenge the charge sheet laid against the driver of the bus. Even after that, my lordship, in the alleged discharge summary, on the very same day of the accident, he was admitted to the hospital with history of RTA. That is immediately to the hospital at Asan. Thereafter, he was immediately shifted to the
Where is that?
boring
Summary?
discharge summary, which is in page number 62 in the trial court PCR, my lordship. And IME report was conducted after lapse of 17 or 18 days from the date of alleged accident. And no damages were found at that time. It got repaired. Discharge summary of Lady Karjan Hospital at Bangalore, which is in exhibit P11, my lord. It is specifically indicate that alleged history of RTA two-wheeler collided with bus on 9/7/2012. At the first instance, the information has given the manner which accident has been taken place and claimant got injured.
Where is it mentioned that there is collusion? Alleged history
Two-wheeler
of
collided
motor
with
accident after?
this. That is a certified copy of the and no independent witness are examined to prove their case that the negligence on the part of the rider of the motorcycle.
This document is not marked,
It is there in the lower court records, my lordship.
is there, but it is not marked.
If that is the case, they would have lodged the complaint to say their grievances before the competent authority by stating that my vehicle is not involved in the accident. There is no negligence on part of the driver of the KSRTC bus. Entire negligence on the part of the rider of the motorcycle. And apart from examining the driver of the KSRTC, no other either inmates of the bus or any other conductor or any other independent witnesses are not examined. Only by relying on the photographs produced on behalf of the KSRTC, they have took the defense that the KSRTC bus, there is no negligence on the part of the KSRTC bus. It is utmost caution on the part of the heavy vehicle to safeguard the interest of the rider, motorcycle rider, my lords. There is no substantial evidence and proof produced on behalf of the KSRTC to deny the involvement of the KSRTC bus in the alleged accident, my lordship. There is no contra evidence led by the KSRTC and no iota of materials produced and to prove their case. In the absence of the same, whatever the findings recorded by the tribunal is held proper, my lordship, and seeking for enhancement of the compensation.
What ground you are seeking enhancement?
The income taken by the tribunal is on lower side, my lordship. He was inpatient for a period of 10 days. Disability assessed by the doctor is 23% to the whole body. And tribunal has assessed the disability only to the extent of 12%. And 9,000 income is taken, that is required to be enhanced, my lord. As per the chart, it has to be taken 11,000.
Pain and suffering, 75,000.
That is held proper, my lordship. And medical expenses also, there is no interference.
We don't find any.
Towards diet and food, there is no interference, my lordship. And towards the future income, it is required to be enhanced, and towards the loss of income during later period, no compensation is awarded. And towards the amenities, nothing was awarded by the tribunal. On those sides, it is required to be enhanced, my lordship. Disability considered by the tribunal is on lower side, that is required to be enhanced because there is a shortening of leg about 2 feet.
2 feet?
Allah, 2 inches, sorry. Three inches. To whole body, as per the assessment of the doctor, 23%, my lordship. But tribunal is considered only 11%.
The tribunal opined that the appellant is entitled to 50,000 towards pain and suffering. At para 19 of the order.
Para?
19.
That is required to be reduced.
Awarded 75,000.
But it awarded 75,000.
That required to be modified.
And at para 21, the tribunal opined that he is entitled to rupees 54,000 towards loss of income during late.
That was not forthcoming in the
Order, yes.
disability has to be enhanced, my lordship, taking note of the injury sustained by the claimant. And there is a shortening of 3 feet.
Up to 3 feet.
Sir, 3 inches of left leg. ಏನಮ್ಮ? ಹ್ಮ್. Next week ಹಾಕ್ಸ್ಬಿಡಿ.
26 years.
ಹಾಕ್ಸಿ.
Yes.
So I have, suppose if he completes, my lords, I have to reply. Lords, my learned friend has said, IMV report was prepared after 9 days. There was no occasion because he filed a complaint after 9 days. Therefore, only the criminal law set into motion, the question of the assessment of damages to the bus arises. Therefore, that is not correct, his submission.
Yes, the bus was at that place only.
No, bus was not at that place because it is a case that the bus not at all involved in the accident. Therefore, the bus has gone. There is no question of therefore the driver also did not think of lodging any complaint because it did not touch the bus. Number one. MLC record, he says the MLC record, my lords, that it is his averment before the medical authorities saying that it is an accident. Can we only on the basis of an averment made in the MLC record, can we come to a conclusion that the accident has taken place because of XYZ? So this cannot be a concrete evidence to jump into a conclusion that the bus was involved in the accident. My lords, there is, according to him, my lords, the utmost caution should have been taken by the bus because of the heavy vehicle. My lord, kindly, therefore, my lord, I stressed. Now also I am stressing, my learned friend did not speak anything about the spot measure. From looking at the spot measure, the bus on its proper side in the extreme left side. How can we expect the bus driver to do anything more than that? That's an accident took place in a curvature. He lost control and he came towards the bus, and after seeing the bus, he fell down. That is the case, my lord. Suppose, therefore, my lord, I said, suppose if your lordships are not agreeing for a moment without prejudice to my earlier arguments, your lordship should also consider the contributory negligence. Suppose if your lordship is of the opinion that the charge sheet has not been challenged and no complaint has been lodged, by looking into the spot measure, my lord, it's a police record. The tribunal says that the tribunal has proceeded on the basis of the police records. Spot measure is a police record. They themselves have prepared it. Suppose the spot measure to be disbelieved, that's a different matter. I have no case. Suppose once the spot measure has to be believed, then the bus, the spot of the accident is on the extreme left side. The bus driver cannot be found fault with. That's my humble submission. As far as the enhancement is concerned, my lords, it has been, except by stating that the 9,000, 11,000, and in other heads that the proper compensation has been awarded, and even disability also 1/3 has been taken into consideration, is correctly assessed.
So the notional income is required to be increased.
My lords, it's 9,000. As per the chart, it is 11,000.
11,000.
Only to that extent. Suppose if your lordships is the opinion that.
As per the medical evidence, my lordship, 23% to the whole body.
11% comes to 1/3. It's correctly
No,
assessed.
it is specifically stated for whole body, not to the particular limb.
Fracture of femur.
Sri Girish P. Baldari. Heard Sri G. Lakshmesh Rao, Land Council. This is a earlier file, 1685. This is heard Sri G. Lakshmesh Rao, Land Council, for the appellant in MFA 4886 of 2021, who is appearing for the respondent in MFA 6523 of 2021. Full stop. Also heard Sri Girish B. Baldari, Land Council, for the appellant in MFA 6523 of 2021, who is appearing for the respondent in MFA 4886 of 2021. Full stop. Submissions concluded. List the matter under the caption for orders on under the caption for dictating judgment on 23rd September.
Grateful.
Good job, lady.
Serial number 41, K.M. Somashekar, K. Suryanarayan Rao.
No representation on either side on call. Through order dated 16/2/2022, Sri K. Suryanarayan Rao was directed to take notice for respondent number 2. Full stop. However, no wakalat is filed till now. Full stop. Therefore, issue notice to respondent number 2 on furnishing the requisites. List on 4th November.
Serial number 42, Narendra Gowda, BC Sitaram Rao for respondent.
My lords, I appear for the respondent in this matter, my lords. I speak,
1 minute, Mr. Counsel, in the earlier matter where ECA price compensation 2010 amendment. I discussed about 2010 amendment. You take out the copy of amendment and give it to me. Employees compensation. The 2010 amendment where the income is increased to 8,000. Yes, Mr. Counsel.
my lords, I request for a short accommodation in this matter, my lords.
No representation on appellant side on call. Sri Anup Sita Ramarao appears through VC representing the Sri VC Sita Ramarao, counsel on record for respondent number 2 and seeks time. Hence stand over to 411.
Serial number 43, Srinivasan MY. Yes, Nirmala.
I am for the appellant in 937 of 21, my lord. My lord, we have not received any copy for the appeal what they have filed in 1927 of 2022, my lord. And the office has given an endorsement, my lord, saying that the respondent has died. We don't know, because that is why I have asked the corporation to take to find the LRs, my lord.
In my appeal, this is not a case of take notice, my lord. I have already given notice. So the case certificate has received a copy, and after that, she filed a, my lord.
Whether the appellant is
No, my lord.
alive or
In
not.
case certificate appeal, my lord, I have received information. Party is alive.
I'm sorry, my lord, because
I
the
have not.
office.
I have not received, my lord, the copy of appeal copy of case RTC since, my lord, the endorsement is party died.
That is what the office has given, my lord. We have sent the notice directly to the address available to the party along with the copy of the appeal, my lord. Now the office has put up.
Directing the, my lord,
No, it is not the advance. My lord, when my appeal came, there was no respondent advocate. Only the respondent and ex parte order I have taken it. The court has kindly stayed the order and then directed me to send the notice along with the available address, whatever in the appeal, my lord. We have sent the notice along with the appeal copy, my lord. Now the office has put up, this is second time, my lord, it's coming saying that the respondent died. I have asked the corporation for investigation to find the LRs.
now, my lord, I have received information.
We cannot believe,
Party is
my lord,
alive.
unless proof is given
Party
that
is
he is alive, my lord. Because at the time of accident, he was 60 years already, my lord. We have to take some proof because we cannot just believe the advocate words, my lord. Because when the office has given clearly saying that the respondent is deceased.
Office has not, my lord, endorsed, my lord.
Where is the
The
office
party is died.
endorsement that
The
the
postman, my lord, whoever, my lord,
The postal sheriff.
The office has to believe the endorsement, my lord. It is not that the office will go and serve the copy.
yes. Notice, my lord, already, my lord, normally, my lord, going through post of, my lord, post service. The postman has, my lord, the put an endorsement, his party died.
That we don't have any proof, my lord.
I have received information after this endorsement, my lord, the party is alive.
Heard. Sri Srinivasan MY as well as Sri Srinivasan MY who appears physically before this court as well as Srimati S. Nirmala who appears through VC regarding the existence of the claimant. Full stop. Sri Srinivasan MY submits that the claimant is alive. Full stop. On the other hand, Srimati S. Nirmala, representing the post, on the other hand, Srimati S. Nirmala, relying upon the postal endorsement, submits that the claimant is no more. Full stop. Having considered the contradictory submissions thus made, to ascertain, the claimant who is The appellant in MFA 1927 of 2022 is directed to make his physical appearance before this court on 29/10/2024.
Much obliged.
List on 29/10/2024.
Much obliged.
My lord, direct him to serve copy, my lord, I have not received.
Let him present, thereafter we'll see.
Please. Date, my lord.
29/10.
2910. Serial number 44, Pradeep Kesi, Muralidhar N.
For appellant, my lords, I pray for short accommodation, my lords. I have informed the respondent, my lords. They have also filed a appeal, my lords, challenging the liability, my lords.
You have to take steps in respect of respondent number. Where is the postal share in respect of respondent number 4?
My lords, I'm the appellant in 2543 of 22.
3253 of 22. 3253 of 20. Yeah. Notice sent to respondent number 4 in MFA 3253 of 2022, returned with an endorsement unclaimed. Full stop. Hence, service is held sufficient. Full stop. No representation for R4. Full stop. Recorded. Yes. Next. List both the appeals on 24th October. Please.
Serial number 45, Raja L. Bhirini
case-
Shivananda.
This case appear for the appellant.
I appear for respondent, my lord.
This climate appeal, case of death, my lord. Trial court is awarding 17,21,200 rupees, my lord. The trial court is error. This is the appellant, climate is 1 to 5 is there, my lord. Tribunal is deduct the income is 1/3, my lord. 1/5 is deduct the income, he wrongly taken the deduct the income is 1/3, my lord.
How much should be deducted?
1/3 deducted.
How it should be 1/3 when the claimants are 5 in number?
Climate is a first to appellant is wife, second to and to fourth is sons. And fifth is mother is this is my. This all climate. This 1 to 5th is there. Trial court is only 1/3 is deducted, my. And also age is in the postmortem report is 44 years, my lord. Tribunal is to take the age is 52 years. That's
You have produced the Aadhaar card. As per exhibit P20 Aadhaar card, the date of birth is 1/1/1969.
69 is
Then age is 52 years.
Aadhaar card is postmortem report is 44 years, my lord.
Maybe your document itself, his Aadhaar card reveals the date of birth.
Even 69 also 49 years age in the year 2019 accident.
69.
16.
2009. It comes to 50 years.
50. And loss of conservation, only 50,000 is awarded.
2019, 14,000 taken, it is proper.
Future income.
Future prospects, 25% proper.
Lord. Three major sons, my lord.
Deduction should be 1/4.
1/4.
Multiplier should be 13, not 11. Yes, Amma, what is your submission?
My lord, three major sons, my lord. Three major sons and mother and wife. So 1/3 deduction, what they have done is proper, my lord.
It should be 1/4.
And they have not shown that the major sons were dependent.
Yes. Yes,
So 1/3 deduction is proper, my lord.
next.
Next is, my lord, as per the Aadhaar card, will be 52 years.
Yes. It is 50 years, Amma. As per Aadhaar, even as per Aadhaar card, it is 50 years.
He is 50, then 25% is taken, my lord.
50,
And that will be
25%
proper.
is taken. That is proper. However, the multiplier will be 13, not 11.
Yes, my lord. If he
Any
is
further
50, it
submission?
will be 11. And spousal consortium 50,000 is given. Parental
Yes.
consortium 60,000 is given. Filial consortium 50,000 is given.
Yes.
Totally 1,60,000 is given.
Yes, yes, that will be recalculated. Yes. Any further submission, Amma?
No, my lord. So since there are three major sons, 1/3 deduction is proper, my lord. That's all.
Heard. You are Mr. Raja L.
Yes.
Heard. Sri Raja L. Learned counsel for the appellants who appears physically before this court, full stop, also heard Srimati Harini Shivananda, Land Counsel for Respondent number 2, who appears through VC. Next. The wife, comma, 3 sons, and the mother of the deceased Bomma Lingayya, alias Krishnappa, who died in a road traffic accident that occurred on 14/2/2019, filed a petition claiming compensation of rupees 60 lakhs in total. Full stop. The Motor Accidents Claims Tribunal Maddur, which dealt with the matter as MVC 443 of 2019, passed orders on 3/1/2022, holding that they are entitled to a sum of rupees 17 lakhs 21,200 as compensation. Full stop. Dissatisfied with the same, comma, the claimants are before this court seeking enhancement. Full stop. Sri Raja L, Land Counsel for the appellants, contends that as per Exhibit P8 postmortem report, comma, the deceased was aged about 44 years by the date of accident. Full stop. However, the tribunal took the age of the deceased Bomma Lingayya, alias Krishnappa, within brackets hereinafter referred to as the deceased for brevity, as 52 years, which is erroneous. Full stop. Land Counsel also contends that the dependents are 5 in number. Full stop. Therefore, as per the decision of the Honorable Apex Court in Sarla Verma's case, comma, 1/4 of the earnings are required to be deducted towards the personal and living expenses which the deceased would have incurred for himself had he been alive. Full stop. However, the tribunal deducted 1/3 of the earnings. Full stop. The Land Counsel thereby seeks to recalculate and to award the amount claimed. Full stop. Next paragraph. Per contra, the submission that is made by Srimati Harini Shivananda, Land Counsel for Respondent number 2, is that the sons of the deceased attained the age of majority by the date of accident. Full stop. Therefore, they cannot be considered to be the dependents of the deceased. Full stop. Thus, the tribunal has rightly took the notional income, rightly deducted 1/3 of the earnings towards personal and living expenses. Full stop. Next. Coming to the age of the deceased by the date of accident, comma, the tribunal, placing reliance upon Exhibit P20 Aadhaar card, comma, took the age of the deceased as 52 years by the date of accident. Full stop. As per the contents of Exhibit P20 Aadhaar card, the deceased was born on 1/1/1969. Full stop. It is not in dispute that the accident occurred on 14/2/2019. Full stop. Thus, the deceased, even as per exhibit P20 Aadhaar card, is aged about 50 years by the date of accident, but not 52 years as observed by the tribunal. Full stop. Therefore, the age of the deceased for the purpose of calculating compensation is taken as 50 years by the date of accident. Next paragraph. Coming to the deduction towards personal and living expenses, comma, as rightly contended by Srimati Harini Shivananda, comma, the three sons of the deceased, that is appellants 2 to 4, attained the age of majority by the date of accident. Full stop. Their age is shown as, it is mentioned that the age of the second appellant is 23 years and the appellants 3 and 4 as 20 years by the date of accident. Full stop. There is no proof that they have started their actual earnings. Full stop. The age as mentioned on consideration, the age as mentioned what did you write? As mentioned, comma, it can be safely inferred that they would have been pursuing their studies or have just chosen their occupation. Full stop. Therefore, it cannot be held that they were not depending upon the earnings of the deceased by the date of accident. Full stop. Therefore, considering the dependents to be 5 in number, comma, this court holds that 1/4 of the earnings of the deceased are required to be deducted towards personal and living expenses, which the deceased would have incurred for himself had he been alive. Full stop. Next paragraph. The deceased, being aged about 50 years by the date of accident, comma, 25% of his earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay Sethi's case. Full stop. Also, the deceased the deceased being aged about 50 years by the date of accident, comma, the appropriate multiplier to be applied is 13. Full stop. The notional income as taken by the tribunal, that is 14,000 per month, is proper. Full stop. Thus, the amount which the appellants are entitled to under the head loss of dependency is as under: notional monthly income 14,000, annual income 1,68,000, add 25% towards future prospects 2,10,000, deduct 1/4 towards personal and living expenses 1,57,500, apply appropriate multiplier 13, 20,47,500. Full stop. Thus, the compensation which the appellants are entitled to under the head loss of dependency is 20,47,500. Full stop. Together with the said amount, comma, the appellants are entitled to rupees 15,000 towards funeral expenses and 15,000 towards loss of estate. Full stop. The first appellant, being the wife of the deceased, is entitled to rupees 40,000 towards loss of spousal consortium. Full stop. The appellants 2 to 4, being the sons of the deceased, are entitled to rupees 40,000 towards loss of parental consortium. Full stop. The fifth appellant, being the mother of the deceased, is entitled to rupees 40,000 under the head loss of filial consortium. Full stop. Thus, the total compensation which the appellants are entitled to is as under. Loss of dependency 20 lakhs 47,500, funeral expenses 15,000, loss of estate 15,000, loss of spousal consortium 40,000, loss of parental consortium 40,000, loss of filial consortium 40,000. Total 21 lakhs 97,500. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 17 lakhs 21,200 as compensation. Full stop. However, the justifiable sum which the appellants are entitled to is 21 lakhs 97,500. Full stop. Therefore, the appeal is disposed of with the following order. The appeal is allowed in part. Compensation that is awarded by the Motor Accidents Claims Tribunal, Maddur, through orders in MVC 443 of 2019, dated 3/1/2022, is enhanced from 17 lakhs 21,200 to 21 lakhs 97,500. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. The apportionment made applies to enhanced sum as well. Full stop. On deposit, the appellants are permitted to withdraw their respective sheets.
Yes, sir. Yes. ಈಗ ಎಲ್ಡರ್ ಬ್ರದರ್ ಕೂಡ ಮೆಸೇಜ್ ಕಳಿಸಿದ ಏನಾಯ್ತು ಕೇಳಪ್ಪ ನಾನು ಅಸಿಸ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಬಟ್ ಅದಕ್ಕೆ ಏನು ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ.
Serial number 46, 47 adjourn. 48 Gopalakrishna N, KN Srinivas.
In this case, my lord, the case of death, my lord, can you be referred to local adalat?
At request of Ms. Susmita G, Land Counsel, who represents Sri Gopal Krishna N, Land Counsel on record for the appellants, the matter is referred to Lok Adalat for settlement.
Much obliged.
Serial number 49 adjourn. 50.
My lord, I am for the respondent, my lord. This matter is already settled between the parties for 2 lakh rupees. Kindly refer this matter to Lok Adalat. We will report the settlement.
And appellant side on call. You have not filed your wakalat, Mr. Vijay Kumar.
My lord, this matter was posted before Lok Adalat. We have discussed it. The company is getting the approval also and send the wakalat.
Seeks time to file wakalat. Stop. He also seeks to refer the matter to Lok Adalat for settlement. Stop. Time for a week is granted to Sri D. Vijay Kumar to file wakalat. Stop. The matter is referred to Lok Adalat for settlement.
Serial number 51 D. Vijay Kumar, Sagar BB for respondent.
Password, my lord, senior will is held up in court all 3 minutes.
Huh?
Serial number 51.
What is your submission, Mr. Counsel?
Password, my lord, sir, senior would appear, he's held up in court all 3 minutes.
Pass over the matter. Even the, Mr. Court Officer, even the Passover matter should be heard now itself. Afternoon, we are having DB. No representation on appellant side on call.
My lord, I am for appellant, my lord.
Yes, Mr. Counsel.
My lord, I am ready.
Pass for me.
We can avoid the liability.
Senior is held up in court of 3 minutes.
We'll call it at 1:30.
ಫಂಡಮೆಂಟಲ್ ಪ್ರೀತಿ ಇದ್ದಾಗ ಓನರೇ ಕೊಡ್ಬೇಕು ನಾವು ಕೊಡಲೇ ಇಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Please.
Serial number 52, Jagadish HT, B Pradeep for R2.
I for the appellant in this case, not climate supplement seeking enhancement of
Ashok N Patil.
call for TCR, TCR may be necessary.
Mr. Pradeep, you have not filed your.
Ashok N Patil
Ashok N Patil is fine.
has been interested to Ashok N Patil. My name may be deleted.
Heard Sri Jagadish HT, learn counsel for the appellant as well as Sri Ashok N Patil, learn counsel for respondent number 2. Admit, call for the records from the consent tribunal, list the matter under the caption final hearing on 13th November.
Please.
Full stop. As Sri Ashok N Patil is on record for respondent number 2, office is directed not to show the name of Sri B Pradeep in the cast list hereafter.
Number 53, Spurti Hegde, D Vijay Kumar for
Appellant,
respondent.
my lord. My lord, it may be referred to Lok Adalat, my lord.
At request of Sri Spurti Hegde, learn counsel for the appellants, the matter is referred to Lok Adalat for settlement.
Please.
Much obliged.
Number 54, Srinivasaya,
Appellant,
D Vijay Kumar for respondent.
my lord, I will intimated by our party, my lord, Wakalat is sending and Wakalat is not yet filed, my lord, that connected matter filed by the.
Sri Srinivas.
I am for the appellant.
Yes, Mr. Counsel, you have not filed wakalat in the connected matter.
In my appeal is also there, my lord, connected appeal by the APSRTC.
What about you filing wakalat, Mr. Counsel?
I will get the wakalat, my lord.
Learn counsel Sri Srinivasaya A as well as Sri D Vijay Kumar seeks time to file wakalat for respective parties.
The petitioners are seeking enhancement of compensation, whereas the insurance company is questioning the
Disturbance is sir.
legality of the.
Please, my lord.
Party will be referred to as.
Mr. Court Officer.
Please, my lord.
Where, in which matter, from which?
D Vijay Kumar.
We are getting disturbance, and if there is a repeated disturbance, we'll direct the registry to block.
Sir, ಅದನ್ನ ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಇಲ್ಲ ಮಾಡಿದೆ ನಮ್ದೇನು ಇದು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಹಿಂದೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್.
Oh, sorry, my lord.
Sri for respective parties. Full stop. Time for 2 weeks is granted. List on 25th October.
Much obliged.
Serial number 55, Prakash MH, AN Krishnaswamy for R1. Serial number 55,
No representation on either side on call. To give fair opportunity, list on 12th November.
56 adjourned, 57, Kailash Shankar, PS, Manjula Tejaswi for respondent.
I'm appealing for the second respondent.
Take case of
Appealing for the second respondent in this case, Your Lordship. Ready for the matter.
income has to be enhanced. The date of action is 9/8/2020, my lord. And this is aged 34 years, and his occupation is professionally is a painting worker. And we have claimed 25,000 per month, but tribunal assessed 12,750 per month. That's all. That has to be enhanced.
So now what is your submission?
Madam ಹೇಳಿ ಮಂಜುಳಾ ತೇಜಸ್ವಿ.
Your lordship, as per of the deceased, as he has failed to prove his income and avocation, your lordship. So there is
What
no
is it?
question of
Please come
enhancement at
again.
all, is my humble
You're not
submission.
properly audible, Amma.
Your lordship, the tribunal, as per the Minimum Wages Act, has considered 12,750 per month as the income of the deceased. As such, there is no need of enhancement of compensation under that head is my humble submission.
Tribunal considered minimum wages.
Paragraph 23 may kindly be as 12,750 per month has been taken as the income, your lordship. As per the Minimum Wages Act, paragraph 23 of the 23 and 24 of the tribunal's judgment, your lordship.
What was his occupation?
Painter.
Paying, but they have not proved, your lordship, neither the avocation nor the income they have proved. So the tribunal, they have even para 23 and 24 may kindly be considered, your lordship, the tribunal's judgment. They have even said Mysore comes under the division number 1, and as per the Minimum Wages Act applicable to that area, that amount has been considered, your lordship.
Recent judgment of this honorable division bench of this honorable court, notional income of local has to be considered, not minimum wages.
So 2020,
Please, madam, 4,500 has to be taken into consideration.
4,500,
Please, madam,
14,500.
14,500, please.
Yes. Mr. Court Officer. Heard. Can the record be posted tomorrow? Heard. Sri Kailash Shankar PS, and counsel for the appellants who appears physically before this court. Also heard Srimati Manjula and Tejasvi, and counsel for respondent number 2 who appears through VC. Submissions concluded. List the matter on tomorrow is 20th. List the matter on 29 under the caption for dictating judgment.
Obliged.
Yes, make it fast.
Serial number 58, Ravi MM.
Refer to the local.
Second.
At request of Sri Ravi MM, Land Counsel for the appellants, and Sri C. Shankar Reddy, Land Counsel for respondent number 2, the matter is referred to local for settlement. Yes.
Serial number 59, Parmeshwaraya DC. HS Lingaraju.
Claimant, my lord.
Paper third respondent, Lingaraj has got some personal inconvenience today.
Either TCR is necessary, my lord. And then, my lord, the connected matter, say,
Parmeshwaraya DC.
please,
Connected matter?
please, my lord, same accident, my lord, 12/13 of 2024.
Sri Parameshwaraya DC, Land Counsel for the appellant submits that MFA
12/13.
1230.
1213.
1213.
1213.
of
24.
is connected to the present appeal, seeks to list both the matters on the same day.
Please.
In the light of the submission thus made, register to verify and to list the present appeal along with MFA so and so on 20th November.
Meanwhile, my lord, call for
The
TC.
records from the consent tribunal in the meantime.
Please.
Number 60, Ashok N. Patil, Girish B. Balgara.
This case delay may be condoned, my lordship. There's a delay of 179 days in preferring the appeal in serial number 60/1 and 60/2, my lordship.
Where is the delay petition in 60.3, 60.3?
Yes, my lordship.
Give the file in 68 on page. IA 1 of 2024 in MFA 3813 of 2024 is filed seeking the court to condone the delay of 182 days in filing the appeal. Heard, Sri Girish P. Baldari, learned counsel for the petitioner appellant as well as Sri Ashok N. Patil, counsel for respondent number 1. Any objection?
No.
Gone through the contents of the affidavit given in support of the petition. Having considered the grounds urged, the delay as prayed for is condoned. Full stop. However, the appellant will not be entitled for any interest over and above the amount that is awarded by the tribunal, if any granted by this court through the judgment in the appeal for the period of delay of 182 days. Next. In 60.2, there is 179 days.
Yes, my lord. 3789.
Do that
89
fine. 3789 of 20.
Choblet.
IA 1 of 2024 in MFA 3789 of 2024 is filed, seeking the court to condone the delay of 179 days in filing the appeal. Same amount, change the days. Good stuff. We'll admit all the matters and list for final hearing.
Yes.
Admit all the appeals, list for final hearing on 25th November.
Serial number? 51. Pradeep B. Ramesh Gowda.
For the appellant in this case, we are challenging negligence as well as quantum of compensation.
Lord, sir, that there is a connected matter which is filed by me. In that, the notice to R4 and R5, I'll file a memo seeking dispensation of notice to their matters.
You filed,
I'll file it now.
Why it should be
Because
dispensed?
it is, I've checked, my appeal is on negligence aspect. Apportionment of negligence between the insurers of both the vehicles involved in the accident.
There is only inter-side disputes between the insurance companies, my lord. Therefore, the owners of the vehicle is not necessary.
You file the.
I'll file it,
court
I'll-
officer take it.
I'll give it.
Srimati Geeta or learned counsel for the appellant in MFA 5780/21 files memo seeking dispensation of notice upon respondents 4 and 5. Full stop. Learned counsel states that as the dispute is inter se between the insurance companies, notice to respondents 4 and 5 may be dispensed with. Full stop. Having considered the submission thus made, notice to respondents 4 and 5 stands dispensed with, however, at the risk of the appellant. Next.
Regarding R6, my lord, I will undertake to file wakalat within me.
For
Bajaj Alliance Generals.
Sri Pradeep B waives notice for respondent number 6 in MFA 5780 of 2021 and seeks time to file wakalat. Full stop. Hence, list both the matters on 22nd October.
Metro test.
Serial number 62. Srinivasan MY. P. Pradeep for R2.
This case, my lord, the case of enhancement.
We'll have it on Monday, Mr. Counsel, Monday, not Monday, Tuesday.
2:30.
We cannot-
Tuesday.
Tuesday. At request, list the matter under the same caption on 24th September.
Number 63. Adjourn 54. SV Hegde Mulkand.
My lord, I appear for the apparent, my lord. I don't know other side is ready or not.
Prakash M.
The Hegde Mulkand appears true VC. Full stop. However, there is no representation on respondent side on call. Full stop. To give fair opportunity, stand over to 21st October.
Serial number 65. Harish Babu KN.
21st September.
Appear for appellant in this case.
Yes, Mr. Counsel.
Other side has requested me to, that they are going to take a
I'm
date.
here. Yesterday I informed him that I may be attending a function, but
Yes, we'll have it on Tuesday.
please.
Quantum is in dispute. Huh?
No, my lord, the liability. What has happened is 163A petition. The claim petition is dismissed on the ground that it was because of the self-negligence. That is under challenge.
Sri Harish Babu KN appears.
LCR is required, my lord. Kindly secure the LCR.
TCR is TCR not.
TCR.
CR received.
TCR is received, Mr. Counsel.
Please, ma'am.
Appears through VC. Full stop. Sri Ravi S. Samprati, Land Counsel for R2 is present before this court physically. Full stop. At request, list the matter on 21st October.
Please.
66 adjourn. Bill number 67, Gurudev Prasad KT.
Appear for Lingaraj.
Yes, Lingaraj.
Lingaraj has got some inconvenience today, ma'am.
No representation on appellant side in both the appeals. Good stop. To give fair opportunity, list on 28th October.
Bill number 68, Prakash MH. O Mahesh for R1.
No representation on either side on call. To give fair opportunity, list on 28th October.
69 adjourn. 70, Mahadev Swami P. FS Dabali for respondent.
Same order, no representation. TCR not received.
Awaiting.
No representation on either side on call. Await TCR, list on 28th October. Passover matters.
Passover matters. Serial number 20.
Respondent have filed application to withdraw the amount deposited.
Gita R.
Yes.
This is a case where the claimant was driving a high vehicle. While driving the vehicle, he has gone and hit the lorry which was proceeding ahead of him. The tribunal has apportioned the negligence between the owner, driver of the lorry and the claimant in the ratio 75% and 25%. 25% negligence has been held on the part of the claimant. Against the said judgment, I am before your lordships on the ground that because there was no negligence on the part of driver of lorry.
So what is your objection to permit the claimant?
That I don't have objection. My humble submission is, my lords, whatever the amount I have deposited, out of which 50% may be released, my lords.
Yes. Delay condemnation petition is also the delay of 9 days. Any objection?
I have no objection, Miller.
IA1 of
Cross
2022
appeal
is
also,
filed.
cross appeal also have been filed. And the remaining 50% at the time of final argument, final hearing. It may be.
IA1 of 2022 is filed seeking the court to condone the delay of 9 days in filing the appeal. Full stop. Third, Srimati Geeta R. Land Counsel for the petitioner appellant, as well as your good name?
Nagraj wife.
Huh?
Nagraj wife.
Nagraj, who represents Sri
Shankar Reddy.
C. Shankar Reddy, Land Counsel for respondent number 1. Full stop. There is no representation for respondent number 4. Full stop. Gone through the contents of the affidavit given in support of the petition. Full stop. Having considered the ground such, the delay as prayed for is continued. Next. Next, orders in IA1 of 2020.
IA1 of 24 filed by me to withdraw the amount deposited.
Yes. So there are two insurance companies, National Insurance Company and ICICI Lombard.
Yes, ma'am.
So who deposited the amount? You
Have deposited. National Insurance Company, my lords. It's my appeal.
Yes. This is a petition filed by the claimant who is arrayed as first respondent to the appeal to permit him to withdraw the deposited amount. Full stop. Land counsel, Sri, your good name, Mr. Counsel? Your good name, Mr. Counsel?
Sir,
Your
Nagaraj
name,
Vai.
Nagaraj.
Land counsel, Sri Nagaraj, representing the petitioner claimant, contends that the appellant deposited 50% of the award amount as ordered by this court, and therefore the petitioner claimant may be permitted to withdraw the said amount. Full stop. Next para. On the other hand, Srimati Geeta R, representing the appellant insurance company, contends that the aspect of contributory negligence is to be decided by this court and therefore orders may be passed accordingly. Full stop. Next, having considered the submissions thus made, this court is of the view that 50% out of the deposited amount can be permitted to be withdrawn by the claimant. Full stop. Thus, the petition is allowed with the following order. Full stop. The claimant in MVC 173 of 2015 that stood pending before the Motor Accidents Claims Tribunal Bagepalli is permitted to withdraw 50% of the deposited amount without furnishing any security. List both the appeals on 29/10.
TCR may be called, my lords.
Call for the records from the consent tribunal in the meantime.
Much obliged. Grateful, my lords.
Number 29, passover matter. Satish Shetty,
Paper
Ravi
second
Samprati.
respondent. Lord, this was, it may be taken up next week any day.
At request of Sri Ravi S. Samprati, Land Counsel for Respondent number 2, list the matter under the same caption on 30th September.
Please.
Serial number 34, passover matter. Somshekar KM, Ravish Bending.
Who's after Passover? No representation on either side on call. To give fair opportunity, list on 3930.
Serial number 51.
Respondent.
My lord, I am for the appellant, my lord. My lord, it is only under 3 heads, compensation will have to be reduced.
The court granted excess amount.
Yes, my lord.
Yes, we'll
Multiplier instead of
we'll admit
11.
and list for final hearing next week, Mr. Counsel.
Please, my lord.
Heard Sri T. Vijay Kumar, who appears through VC. Also heard Sri Sagar
Yes,
BP, Land Counsel for Respondents 1 and 2. Admit, list the matter under the caption final hearing at request of both the Land Counsel on 3930.
Much obliged. ಇವ್ರು ಮಾತ್ರ ಇದ್ದು ಅದ್ರು
ಇಟ್ಕೊಂಡಿದ್ರೆ ನಾನು ಕೇಸ್ ವರ್ಕರ್ನ ಕಳಿಸ್ತೀನಿ, ಅದು ಪಿಕಪ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲೇ ಮಾಡ್ತಾರಾ?
ಆಮೇಲೆ ಇದು ಮೇಡಮ್ ಅಮೆಂಡ್ಮೆಂಟ್ CH 2010 ಅಮೆಂಡ್ಮೆಂಟ್ ಹೇಳಿ. ಇಲ್ಲ ಆಮೇಲೆ ನೀವು ಇದು ಮಾಡಿ, ಅದು ಹಂಗೆ ಇಟ್ಟಿರ್ತಾರೆ, ಆಮೇಲೆ ಹೋಗಿ ಇದು ಮಾಡಿ ಪ್ರಿಂಟ್ಔಟ್ ತೆಗೆದ್ಬಿಡಿ. ಅಂದ್ರೆ ಹೋಗಿ ಅದು ಹಂಗೆ ಇಟ್ಟಿರ್ತಾರೆ, ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಿಡಿ ಇವ್ರಿಗೆ ಧನಲಕ್ಷ್ಮಿ. ಆಮೇಲೆ ಫೈಲ್ ಇಲ್ಲಿ ಕಳ್ಸಲ್ಲ, ಅವರು ಜಾಸ್ತಿ ಇರ್ತಾವೆ, ಅಲ್ಲೇ ಇದು ಮಾಡ್ಬೇಕು. ಆಮೇಲೆ ಮಾಡಿ ಆಮೇಲೆ ನಾನು ಸ್ವಲ್ಪ ಇದು ಬೇರೆ ವರ್ಕ್